Open the dialogue. And now, as indicated, I will turn to my colleagues, the members of the committee, who would present some questions. We will be covering today the first half of the list of issues. There are 25 issues in the list of issues. We have decided among ourselves to first deal with issues number 1 and 12. But also to deal with number 14 today. So we are going to do 1 to 12. We're going to skip 13. We'll come back to 13 tomorrow, and we're going to do 14. This will ensure a good division of labor between the various members of the committee who have asked already for the floor. So without further ado, I'm now surrendering the floor to Madam Cran. You have the floor, Madam.
Thank you, Mr. Chairperson, and I would like to this afternoon welcome the sizable delegation from Laos PDR. This is Laos' first report to the committee, and I would like to thank the State Party for this initial report and for your presence here. We are sincerely hopeful that this first engagement will mark the beginning of a close, a constructive and fruitful collaboration with our committee. As you know, the dialogue between us and the concluding observations that will flow from it have the potential to very positively contribute to Laos's achievement of its human rights obligations, its quest for development, and the achievement of the Sustainable Development Goals, all interlinked goals that the State Party has acknowledged as top priorities. Reporting without delay facilitates the constructive dialogue between us and the State Party, and here I note with regret that the report comes 7 years late, and I would highlight to the State Party the importance of timely reporting. I think now that cooperation has begun between the committee and the State Party, we trust that the next report will be timely. To mention some relevant achievements, I note that Laos has undergone the Human Rights Council's periodic review twice already, in 2010 and in 2015, and has accepted many of the UPR recommendations. As you've said, distinguished head of delegation, the State Party is party to 7 core treaties, all but those on migrant workers and on enforced disappearances. Laos has yet to ratify the optional protocols to the covenant, and I would like to also, at the national level, acknowledge the adoption of the Constitution of Laos with a chapter on fundamental rights and obligations. And I also note the 2009 presidential ordinance on facilitating the implementation of international legal obligations, as well as the State Party's clear intention of, as has been described, building a rule of law state. These are steps in the direction of the realization of covenant rights, a goal that we all wish to see achieved. And as you know well, that goal is largely achieved through on-the-ground implementation of human rights. And I am genuinely hopeful that this first constructive dialogue between us will establish a strong spirit of communication on the implementation of the covenant in Laos, and that our concluding observations will be directly used in the measures you take to build a rule of law state. You may find that some of our questions this afternoon and tomorrow morning are uncomfortable or difficult ones. But rest assured that this joint process has a very positive purpose. As experts, we raise issues, analyze information, and make recommendations, all with a view to putting State Parties in a better position to advance covenant rights, to make, as the head of the delegation has just mentioned, to make human rights as the key or the hub of nation building. And in this regard, I must also mention that the committee has some serious concerns about the protection of human rights in Laos. And these concerns relate to issues such as the lack of space for civil society to operate, constraints on freedom of expression, opinion, association, and assembly, impunity for enforced disappearances, conditions in detention, lack of access to lawyers, the treatment of ethnic minorities, and other areas that we're now going to delve into. We notice that you've put much effort in your report to provide information on the legal framework, and what is especially important for us now is learning how those laws, how that legal framework is implemented in practice. In other words, the achievements and the gaps in implementation that exist, the day-to-day realities that people in Laos face in terms of the exercise of their rights under the covenant. And by your presence here, you've already signaled your recognition of the value of the engagement between us, and we hope you share this purpose of the dialogue as a valuable opportunity to chart a course for the future in line with the covenant. So on that note, we hope this will be a frank and productive first dialogue between us. I would now like to ask certain questions canvassed in issues 1,
This is AP
2,
News
3, and 12. In your written replies, you've stated that there are provisions of national legislation are inconsistent with treaties, provisions of the treaties will prevail. Please tell us how often the treaties have been found to prevail over inconsistent national legislation. If you could provide us with a list of cases in that regard over the past 5 years, we would appreciate it. And as well, we understand that a lot of law reform efforts have been taking place and are underway. As you go about the law creation process, please clarify the procedures that you have in place to ensure that the national legislation is fully compliant with the covenant prior to its promulgation. You have stated that the courts have not directly referred to the provisions of the covenant. I note the presidential ordinance regarding the supremacy of treaty obligations. Please indicate what steps are being taken to train the judiciary on ways to apply the covenant in domestic law and in court decisions, and the changes that any training may have brought about in their professional performance. Moving to question 2 on the subject of reservations and interpretive declarations, you've indicated that you need the reservations that make the application of freedom of association subject to national laws, and that you need the interpretive declaration on self-determination and on freedom of thought, conscience, and religion, and that you are not ready at this time to withdraw these reservations and declarations. Could you please provide information on why the reservation and the interpretive declarations are considered necessary or were considered necessary, and if you could kindly clarify what conditions would be required for you to withdraw these particular reservations. And kindly explain how the national context and reality that you've referred to affects the state party's implementation of covenant rights. Laos has yet to sign or ratify the optional protocols to the covenant, including the first optional protocol that recognizes the competence of this committee to receive and consider communications from individuals. And we would appreciate any information on plans to ratify our optional protocol. And please tell us what elements would need to be in place for you to proceed with ratification, whether you're open to receiving external support, including support from the Office of the High Commissioner for Human Rights. They, of course, have a regional office in Bangkok that could assist. This would be useful information for us. Moving to question 3, The committee notes that rather than establishing a national human rights institution based on the Paris Principles, as both universal periodic review sessions have recommended, you have asked, or you've decided to task national commissions with promoting and protecting human rights in the country. Our committee favors the setting up of a Paris Principles compliant national human rights institution. Can you tell us about the measures that are in place to ensure the independence of the existing commissions as they review state actions? Please also tell us whether the national commissions address the full range of rights covered in the Human Rights Treaty that Laos has signed. I note that the bodies that you mentioned are being strengthened deal mainly with the rights of children, the rights of women, and the rights of the elderly. And please tell us the conditions that would be necessary for the state party to establish an independent human rights institution, and what would be necessary to assist with a possible transition from the existing national commissions to an independent human rights institution. Have you sought assistance from groups in other countries for this purpose? For example, the Asia-Pacific Forum and the Australian and New Zealand commissions. I understand there is interest in supporting you in this regard. Turning now to the issue relating to enforced disappearances. We believe that this issue is a particularly pressing issue that requires your specific responses. It's been almost 10 years since Laos signed the Convention on Enforced Disappearances, but no progress appears to have been made to ratify the treaty. We'd be grateful if you could please indicate to us what concrete steps the government has taken toward the ratification of the Convention on Enforced Disappearances. The committee would also like a clearer view of your investigations into enforced disappearances. Please indicate the number of investigations into all cases of alleged enforced disappearances since 2008, including the number of open and ongoing investigations and the result of these investigations. Please provide information on the availability of an effective remedy for complainants in these situations. And on a very specific point, are efforts made in these cases to return the remains of disappeared persons to their families, which is so culturally important? Please indicate whether Laos has considered inviting the UN Working Group on Enforced or Involuntary Disappearances to visit Laos. I'd now like to move to the case of Mr. Sombat Somphone. Please provide us with detailed information on your investigation of the alleged enforced disappearance of Mr. Somphone in 2012. We require reliable information for you on this. Some of the explanations that we have heard that have come from the government sounded, we require reliable information. How active was the investigation into this disappearance? How many law enforcement officials were assigned to investigate, and at what level of seniority? To whom did they report? How often were updates on the status of the investigation provided to the family and to the public? What sort of information was provided to them, and when? How has the information that was provided by his wife been used to further the investigation? And what steps have been taken to analyze the CCTV video footage of his disappearance? What is the forensic strategy for the investigation of the apparent disappearance of Mr. Somphone? Has the state party requested technical assistance from other countries to carry out the analysis? And has the state party requested the public prosecutor to open investigations into his case? Will you be establishing an independent commission to carry out an impartial and effective investigation in this case and the other cases of enforced disappearance? Will you be ensuring an independent review of the investigation to date is carried out by a competent and independent expert body? What measures are there currently in place to assist family members of those who may have disappeared? And will the authorities be issuing a status document on the report of the investigation to the relevant court in order to facilitate the issuance of a document confirming Mr. Samponi's disappearance? I know my time is running short now, but this information on enforced disappearances beyond the case that I've just mentioned is important to us. And so I'll simply mention some other cases and look forward to your reply. The allegations of the disappearance of Ka Yang and Hmong people, the information on the forced repatriation of Hmong returning from Thailand in 2012, and the reported disappearance of some of them after their arrival, the specific steps that have been taken to identify the whereabouts of Ka Yang, who was arrested after his second forced return from Thailand. What steps are you planning to take? There are reports that several Hmong men who left the jungle and surrendered themselves to the authorities have been detained and subjected to enforced disappearance. My colleague, Mr. Santos Pais, is going to ask about related matters. Also, please tell us about the steps to identify the exiled Thai activist who was abducted by unknown armed men in Vientiane in this year, and also updated information on the following alleged victims of enforced disappearance: the 2 student leaders who were arrested in October 1999 for organizing a peaceful pro-democracy protest, 9 people, 2 women, 7 men, who were detained by security forces in November 2009 for planning peaceful pro-democracy demonstrations, the critic of Chinese-sponsored agricultural projects, who reportedly disappeared in January of 2007 after uniformed men abducted him. We'd appreciate your very direct replies to these questions, so I thank you in advance for your transparency and your forthcoming answers.
Thank you, Madam Kran. The next speaker on my list is Madam Waterval. Madam Waterval, you have the floor.
Thank you, Mr. Chair, and good afternoon to everybody. Let me join my colleagues in extending a warm welcome to the distinguished delegation of Laos PDR. This afternoon, I will address issues number 4, 5, and 9. Issue number 4 is on non-discrimination and gender equality. The committee has taken note of the information provided in the Common Core document, the initial report, and the replies to the list of issues, and we thank you. As you have stated in the replies, the prohibited grounds for discrimination are enshrined in the Constitution and other laws. However, the prohibited grounds for discrimination appear to differ from one law to the other. The grounds do not appear to be fully consistent with the list of grounds contained in Article 26 of the Covenant. Race as a ground is missing from the Constitution, together with color, sex, political or other opinion, property, birth, are not explicitly covered by other laws. There is also no explicit prohibition of discrimination on the grounds of sexual orientation and gender identity. That is why we urge you to adopt a comprehensive anti-discrimination legislation. And maybe you can elaborate more on this issue. The State Party also replies that it does not yet have a comprehensive anti-discrimination legislation. Not yet. Do we have to take it that there is an intention to have a comprehensive non-discrimination legislation? And if so, can you give us a time frame when you will engage in the process of drafting this comprehensive anti-discrimination legislation? You are also in the process of drafting a law on gender equality, as stated in paragraph 10 of your replies. The question is, what is the status of that bill? You refer to the labor law, and in that regard, we would ask you to confirm that there is no wage gap between men and women. We would like your confirmation on that. In paragraph 19 of your initial report, you have stated that Article 177 of the Penal Law stipulates that any person who discriminates against women and so on. My question is, how many people have been arrested, prosecuted, and convicted on the basis of this law in the past 5 years? My last question on this issue: what is the situation of the elderly people, persons with disabilities, minorities, and indigenous people with regard to discrimination? I turn to issue number 5, that is on hate speech. You have listed some provisions from the penal law that punishes hate speech. You refer to Article 94, 95, and 96. And people who, the prohibition of and punishment of hate speech is defined in some of these provisions. My question is, of these 3 provisions, 94, 95, and 96, how many people have been arrested, prosecuted, and convicted according to these provisions? We would like you to explain what is meant by, and that is from Article 95 of the Penal Law, so any person and so on shall be punished by 3 months to 1 year of imprisonment or by re-education without deprivation of liberty. That is what we like you to explain. What do you mean by re-education without deprivation of liberty? And do you have something like re-education with deprivation of liberty? So maybe you can give us the difference between those terms. Article 68 on the law on media also gives some, stipulates that any person, no, the law on the media, for that we also like to know, it prohibits any person, legal person, and organization to use violence, force, and so on. My question is, how many legal persons or organizations have lost their permit or closed their activities according to this law. In paragraph 13 of your replies, and that is on Article 66, stipulates that any person and so on, and so with the intention of undermining national solidarity shall be punished. We would like to know what your interpretation is of the intention of undermining national solidarity. I turn now to issue number 9. That is the right to life. We thank you for the information provided in the national report and replies to the list of issues. In the process of review of the Penal Code and the debate on the draft Penal Code, the articles imposing the death penalty in the Penal Code were brought for discussion with a view to reduce those articles, and the majority of the National Assembly members voted for reducing articles with death penalty from 18 to 12, abolishing the mandatory imposition of death penalty. That is what you have stated in your replies. My question is, which are the 6 articles, the reduced 6 articles, and can you confirm the abolishing of the mandatory death sentence? Although you have been practicing moratorium on its use for about 30 years, you still have not made it an official moratorium on execution. And we would like to know why. You have also stated in your replies, up to present, about 315 persons received death sentence for the most serious crimes they have committed, particularly drug offense. That's in paragraph 29 of your replies. One of the committee's functions is to interpret the provisions of the covenant. In that way, state parties have some guidance in reporting to the committee. The interpretation of the provision of the covenant are in the general commands. We are in the process of adopting General Command 36 on Article 6 on the right to life. We are in the second reading. In this general command, and we hope to adopt the general command this year, next session. In this general command, we also have the inputs of state parties. In paragraph 39 of General Command 36, it is stated, the term most serious crime must be read restrictively and appertain only to crimes of extreme gravity involving intentional killing. Crimes not resulting directly and intentionally in death, such as drug offenses, etc., although serious in nature, can never justify, within the framework of Article 6, the imposition of the death penalty. State parties are under the obligation to constantly review their criminal laws so as to ensure that the death penalty is not imposed for crimes which do not qualify as the most serious crime. My question, how many of the 315 persons on death row are for drug offenses. How many of these persons sentence was commuted to life imprisonment? And how many of them were pardoned by the president? Although you do not execute people, you still sentence them to death. When is the last time that someone has received the death sentence? And what was the offense? Keeping persons on death row without knowing what will happen to them amounts in a violation of Article 7. In conclusion, we urge the state party to officially put a moratorium on execution and subsequently abolish the death penalty and ratify the second optional protocol in abolishing the death penalty. I thank the distinguished delegation for their answer in advance, and I thank you, Mr. President. Thank you.
Thank you, Madam Waterval. And the next speaker on my list is Mr. Santos Pais. Mr. Santos Pais, you have the floor, sir.
Thank you very much, Chair. And I also would like to extend a warm welcome to all the members of this delegation. And I look forward for a committed dialogue from both sides on the issues that raises concerns on both sides too. So today I will be dealing with issues number 6, 7, 8, and 12. The first one will be on issue 6, gender equality. And in that front, the State Party has provided us with a lot of information that I think is to be commended. Although I would notice that the concerns of the State Party in order to pursue gender equality in the country is not necessarily reflected in the balance of the composition of the delegation before us. But probably next time we'll have that opportunity. But you have given us information not only on provisions of the Constitution, on equality before the law and equality man-woman, but also on the principle of non-discrimination. There are several references to policies and laws within your country, namely the law on the development and protection of women and the setting up of the National Commission for the Advancement of Women and the National Strategy for the Advancement of Women. However, according to the National Report for the Universal Periodic Review in 2015, you also stated that the implementation of policies on gender equality and promotion of the advancement of women has not been sufficiently carried out in the society. Many Lao women are still under the influence of their family and traditional stereotype attitudes towards women. And this limits their ability to have access to justice and to receive useful information for their self-development. There are a lot of references to percentages of representation of women in public life. However, according also to this national report, the State Party considers that the number of female government officials in decision-making positions is still not high enough. So coming to the questions that I would like to do in this particular, regarding this particular issue, what steps does the State Party intend to take to increase steadily representation of women and to ensure gender equality and non-discrimination, both in public life, particularly as government officials in decision-making positions, and in the private sphere? What steps does the State Party intend to take to raise awareness in society for women's rights and to combat family and traditional stereotype attitudes towards women? And what measures does the State Party intend to adopt to ensure greater empowerment of women, particularly in rural, remote, and mountainous areas? Coming now to issue 7, state of emergency and counter-terrorism measures. The State Party makes references to how the declaration of emergency is provided for in the Constitution by the President, refers to the applicable laws, refers also to the responsibilities of the People's Security Force. Nevertheless, it seems that the public emergency has never been declared in the country since quite a number of years. So the question would be, under the law on national defense, is it possible to comply with the conditions for declaring public emergency and the related obligations foreseen in Article 4 of the Covenant, namely through explicit prohibition of derogation from non-derogable human rights and fundamental freedoms laid down in Articles 6, 7, 8, 11, 15, 16, and 18 of the Covenant? Since in your replies you state that the law on national defense does not define the derogations from or restriction of human rights in case of public emergency. So a clarification on this point would be much appreciated. Regarding now the problems on anti-terrorism and universal definition of terrorism, the State Party refers in the replies to the list of issues to the law on money laundering and combating the financing of terrorism. So the questions would be, does the State Party consider that it already has a comprehensive counterterrorism legal framework, including with a definition of terrorism and terrorist activities and legal safeguards for persons suspected of or charged with a terrorist or related crime? Does the State Party consider the broad definition of terrorism in the law on money laundering to be in line with international standards and the Covenant? Since I have read through the definition in this law, and it encompasses quite a large number of different situations. And finally on this issue, are the provisions laid down in the law on criminal procedure as regards protection of the right of suspects of persons charged with a terrorist or related offense the same as for other offenses, or are there particular provisions on the rights of these persons? Now moving to issue number 8 on violence against women and children and trafficking in persons, namely of women and children. The State Party report makes a reference to several policies and laws taken up by the country, the State Party, in order to address these issues. And there are indeed in this field a lot of commendable results that have been pursued in those last years. Namely, the fact that there is a national action plan on the prevention and elimination of violence against women and children, and the fact that there are detailed information in the report on trafficking in persons, particularly of women and children, namely at the level of international cooperation with neighboring countries, making particular reference to the establishment of a counseling center for women and children protection to assist nationwide victims from domestic violence and sexual exploitation, including victims from trafficking in persons. So, coming back to the questions first on domestic violence, which steps does the State Party intend to take to encourage reporting of cases of domestic violence and further raising awareness of women and children about their rights and existing avenues for seeking assistance and protection? Which further training will be conducted vis-à-vis relevant law enforcement officials and judicial officers, judges and prosecutors on legal provisions, detection and proper handling of such cases? What measures will be taken to ensure prompt and effective investigation of cases of violence against women and children, appropriate punishment of perpetrators, and adequate remedies to victims. And finally, could the delegation please provide relevant statistics for the last 3 years on the number of complaints, investigations, prosecutions, and convictions, as well on sentences imposed and compensation granted to victims. On trafficking persons, particularly women and children, Laos seems to be a source and, to a lesser extent, a transit and destination country for women, children, and men subjected to sex trafficking and forced labor. Does the State Party intend to strengthen its efforts to implement the 2016 anti-trafficking law by investigating, prosecuting, and convicting traffickers, including complicit officials, as well as child sex tourists? Which further measures will the State Party undertake to disseminate information and to train police and border officials on formal victim identification and referral procedures with a focus on vulnerable groups? Which measures will be taken to ensure support to victims, including male victims, to reintegrate in their home communities? And which measures will be taken against sexual exploitation of children, namely children from ethnic minorities, particularly Mon, Khmer, and Tibeto-Burman, migrant and refugee children, children living in institutions, transgender boys, children working in exploitative conditions, children from rural areas, and children living in poverty? And finally, on these issues, there are allegations that immigration officials may have enabled the illicit transportation of thousands of undocumented migrant workers from China and Vietnam into Laos for work on large-scale infrastructure, mining and agriculture projects, where some of them may have been subjected to trafficking. What measures has the State Party taken to address this problem? And finally, on issue 12 on prohibition of torture. The State Party has ratified the CAT Convention, although not signed the optional protocol to this convention. There are several references in the State Report and the reply to delicious issues to the several provisions of the domestic law on combating abuse of power, of combating torture by police officers or people or penitentiary officials. And there are also references to the penal and criminal procedure law on the need to protect persons from torture, namely the fact that confessions under duress might not be taken up in the court proceedings. However, it seems that also, according to the State Party, it is incumbent upon the offices of the public prosecutors to monitor and inspect the law enforcement in detention and correctional centers, as well as the performance centers officers. In spite of all this legal and institutional framework, former inmates have consistently referred to punishment in prisons in the State Party as amounting to torture and ill treatment, including the practice of punishing inmates by locking their legs in wooden stocks for most of the day, a procedure that sometimes can last up to several months, and prison officers kicking and severely beating prisoners using their hands and batons and burning their genitals and other body parts with cigarettes. As far as effective oversight over prisons and detention centers is concerned, although its independence is protected constitutionally, all levels of the judiciary seem to experience frequent executive interference. And in this respect, according to your constitutional, National Assembly oversees courts and prosecution and appoints or has implications on the transfer and removal both of judges and public prosecutors. And it seems that judges and public prosecutors normally tend to belong to the ruling party. And even local government approves appointments or removal of judges and prosecutors. So coming to the questions in the framework of this scenario that I have just described, which I would like the state party to comment. When does the state party intend to incorporate the definition of torture into its domestic legislation in line with Article 1 of CAT? And I believe this is one of the recommendations that you accepted during the last Universal Periodic Review. Does the state party intend to ratify the optional protocol to CAT? Could the state party provide statistics for the last 5 years on the number of reported cases, prosecutions, convictions, and sanctions imposed on law enforcement and security officers due to physical violence and torture of suspects or prisoners, as well as inform on the reparation provided to victims? What measures does the state party intend to adopt to strengthen the supervision on prisons and detention centers, and to be able to conduct promptly and impartially investigations on all alleged cases of torture or ill treatment? Does the state party envisage to allow for an independent mechanism of oversight over prison and detention centers? And which measures of re-education are envisaged to people in detention, and where are they conducted? And finally, are there still re-education camps operating? Thank you very much.
Thank you, Mr. Santos Pais. The next speaker on my list is Madam Branskeris. You have the floor, ma'am.
Thank you, Mr. Chairperson. And I would like to join my colleagues in welcoming Your Excellency, Mr. Bungkhaut Sangsomsak, and your distinguished delegation. And I hope that we can all look forward to a very constructive and useful dialogue. Today, I will deal with issue 11, and I will have 4 other issues tomorrow. So, for issue 11, in the reply to the list of issues, the state party in paragraph 36 states that unlawful abortions are prohibited, and that Penal Code Article 92 foresees the penalties, including imprisonment and fines, for both the woman or girl undergoing abortion and the practitioner performing it. However, it does not define unlawful abortions, nor specify whether there are any lawful abortions. Could you please indicate whether there are involuntary terminations of pregnancy that are legal under Lao law, and which cases these apply to? Specifically, please indicate whether legal abortion is provided for in cases of a threat to the life of the woman or girl, threat to their physical or mental health, rape or incest, and non-viable pregnancies, and whether there are possibilities to access voluntary termination of pregnancy in other cases, and what the procedures and conditions for accessing this are in practice for all women and girls concerned throughout the territory of Laos. Could you please provide statistics of how many arrests, prosecutions, and convictions there have been, if any, based on Article 92 of the Penal Code annually in the last 5 years, and specifying also sanctions applied? And what measures are considered by the state party to decriminalize abortion? There have reportedly been studies regarding the prevalence of unsafe abortions in Laos, including one in March 2015 that concluded that unsafe abortions are common and that 20 to 50% of women and girls admitted to hospital for gynecological treatment were due to unsafe abortions. The Minister of Health, when presenting the guidelines for health workers' unsafe abortion prevention and care at the end of 2016, acknowledged that unsafe abortions contributed to maternal mortality and morbidity. Could you please provide updated estimates of clandestine abortions and statistics on deaths due to such, including what share of maternal mortality are due to such? Are specific measures to reduce unsafe abortions foreseen in the National Strategy and Action Plan for Integrated Services on Reproductive, Maternal, Newborn and Child Health for 2016 to 2025? And has the guideline on unsafe abortions been used in practice, and has it led to any improvements? How are such developments monitored, including the regional differences? Have specific measures been taken to ensure access to safe abortions throughout the territory of Laos? And could you provide specific information, including figures in this regard? With regard to reports of high teenage pregnancy, I thank you for the information in the State Party report, paragraph 49, concerning education and awareness raising. There have been reports of adolescent pregnancy rates of 94 births per 1,000 girls between 15 and 19 years old. Could you please provide updated figures of these and provide evidence whether such pregnancies have decreased in the last few years? Reports also have indicated that access to sexual and reproductive health services and information is limited for this age group, especially for unmarried young people. Could you please comment and describe what impact has been measured regarding sexual and reproductive health education, and please provide updated information on programs put in place, including in rural areas, also their content and reach. Finally, the committee takes note of the information that maternal mortality rates have decreased to 206 per 100,000 in 2015, which nevertheless remains high compared to other countries of the region. Could you please provide updated figures for 2016 and 2017? The State Party reply to the list of issues includes reference to efforts to improve prenatal and obstetric postnatal care, including free of charge care at all public health centers and hospitals, as well as capacity raising for healthcare provision in rural and remote areas. Please provide information on the impact of these measures and indicate what further measures have been put into place to continue the trend to effectively decrease such deaths, especially noting the issue of regional disparities and the challenge of rural and remote areas. I thank you for your attention and look forward to the answers. Thank you.
Thank you, Madame Brans-Keris. Le prochain orateur dans ma liste.
This now brings me to the next speaker on my list, Mr. Benachou. You have the floor, sir. Thank you very much, Chair. I wish to echo the comments of my colleagues who welcomed the delegation from the Lao People's Democratic Republic. I also hope that this dialogue will contribute to developing and improving the human rights situation in their country. I would now like to refer to question 14 with regard to the maximum period of detention provided for by law before a person arrested or detained is brought before a judge. Now, this is tied to what we call custody in criminal law. In the response that was provided in paragraph 45 and 46, these are the answers from the state party, we see some clarifications with regard to the period of detention for pretrial detention. This pretrial detention period varies depending on the seriousness of the crime or the offense. Now, for minor offenses, it is for 2 months, which can be extended, and for more serious offenses, this is for 3 months at a time, which can also be extended. In any case, however, pretrial detention can never exceed 1 year. This is clearly laid down in the state party's response. I wish to thank the state party for their responses, but I think that the question 14, was not referring to pretrial detention, which is normally handed down by a judge. Rather, it referred to a kind of preventive detention called being placed in custody. So when an individual is detained by the police or another authority responsible for ensuring compliance with the law, or authorized by law to exercise judicial power, well, this is the period when the individual is under the power of the administration, the police, or some other type of law enforcement forces before they are handed to the judge for a ruling. Now, I wish to draw the honorable delegation's attention to the fact that according to the Human Rights Committee's position, particularly General Comment 8, can not exceed a few days. Paragraph 3 of Article 9 in the General Comments states that any person arrested or detained has to be brought promptly before a judge or other officer authorized by law to exercise judicial power. More precise time limits are fixed by law in most states' parties. And in the view of the committee, delays must not exceed a few days. So that could be 2 days, 48 hours. It perhaps could be 3 days. But in any case, it must be a very short period of time. This ensures that the individual who has been detained is not held by the administration for a long period of time, rather than being held under the control of a judge. Now, I believe that the response provided by the state party in its responses here is not exactly related to the question. So I would like to reiterate my question, namely, what is the maximum period for the custody, the period of time for which the prisoner is in the hands of the administration and not yet under the auspices of the justice system. So what is the maximum period of detention for this custody? And what I am particularly interested in, and what the committee is interested in hearing about, is whether there are cases where individuals were detained and held in a prison without being under the auspices of the justice system. So are there cases of time frames, of periods of 1 month or even potentially 1 year? We've heard about this in the information we received. It indicates that some individuals were held in prisons without having been handed to the legal system, that is, without having a legal ruling or a legal the legal system weighing in here. So we received some information on this that indicated that some individuals were held in prisons for months or even years. I won't go into the concrete details here, but we understand that there were cases where they were not handed over to the justice system, where they were always under the auspices of the police system or the police administration. So the question is about the conditions for prisoners in prisons when they are under the control of the administration rather than the justice system or the judiciary. So that is my question. I would request clarification from your honorable delegation with regard to this period under which the individual is placed in custody. What is the legal framework laid down in your national law to differentiate between custody and pretrial detention? Furthermore, in the prisons in the Lao People's Democratic Republic, are there prisoners who are being held in custody for several months or perhaps even longer than this? The second issue I wish to raise is that there are some requests for release for individuals who have been detained. So my question is, if these requests for release, which are addressed to the prosecutor, are they in line with para 9, with 9.4 of the Covenant? This brings me to the end of my comments on question 14, and I wish to thank the delegation in advance for their answers. Thank you very much, Mr. Benachor.
Seeking the floor at this point in time, and you already have a very loaded plate of issues, which is understandable because this is the first time you've been here, and we have been waiting many years to gather all these questions. And of course, we have received a lot of information, as you can see, some of them raising very serious concerns. And the purpose of the dialogue is actually to allow the state party to address the information and to provide us with its own information so that we can evaluate the full information before us. So in order to facilitate this, we will now suspend the meeting for 15 minutes. And you can then discuss how best you want to respond to the questions. I do urge you to try to plan for a response. We spent about an hour and 5 minutes, so we will give the delegation at least an hour and 5 minutes to respond. If you need 5 or 10 more minutes, this is also fine, but then we would want to leave some also time for members to return with follow-up questions. So with this, I am suspending the meeting for 15 minutes.